Now here at last is the legal argument. So far this was pretty much epistemology. Real world epistemology, which is actually much more fun than abstract epistemology. The Daubert ruling. I'm hoping this system is not too unfamiliar to appreciate what the point is. What Daubert does is oblige judges. Remember, judges are just the legal referees in the common law system. Right? They're not examining magistrates. They're not themselves assessing the evidence normally. They are determining what evidence the jury is allowed to hear. If they don't allow a piece of evidence in, if they rule it out as inadmissible, the jury will never have it. And in many cases, if you rule out the plaintiff's experts, the consequence is that the judge will direct a verdict for the plaintiff. Because for the defendant, the plaintiff can't prove his case without this testimony. If it's not let in, then there is no case, and the judge says, go away, you've lost. The jury never gets to hear it. Now what Daubert obliges courts to do is to screen each item of testimony individually for reliability. At least a court will look at each witness individually. And in some instances, courts look at which particular thing that the expert proposes to say he may be allowed to say. Okay. So this imposes a kind of atomism on the whole system. What the court is asked to determine is, I have no idea what this means, but this is what courts do every day. Determine whether this testimony has been shown by a preponderance of the evidence to be reliable enough to be admitted. I have no idea what that means. It's a bit like the Texas death penalty law, which says that you can only get the death sentence if the jury finds that beyond a reasonable doubt there is a probability that you will be dangerous in future. Iterated epistemic operators are really weird. But what we've got here is evidentiary atomism imposed by law. Look at it one piece at a time. And while my argument isn't that combining evidence always raises worry, sometimes what you've got is just a pile of weak evidence. Sometimes it does raise worry. Sometimes you've got an interlocking bunch of evidence which is much stronger. Since it may, however you interpret the required standard of proof, one little extra bit might be enough to reach the standard. You might be, suppose it's 50%. Suppose you're at 49.5. Then just one little bit of evidence, very, very weak, might be enough to push you over it, but might get excluded under Daubert. I tried to get the feather on the scale, but my PowerPoint skills are not good enough. Just a feather might be enough to tip the scale so that the different side wins in such a case. Now, some people will say, when I say some people, I think I probably mean Professor Ronald Allen mainly, since he keeps saying things like this. No, you don't understand about Daubert. The point about Daubert, he will say, is to educate jurors. I think you can see, if you'll pardon my French, that this is bullshit. Look, what judges may do is avert bad jury decisions by keeping out evidence they think will sway the jury, but that they think is bad. That's not educating the jury, it's preventing it from doing what you think it will do that's bad. And in any case, who's to say that judges are any more competent to assess the worth of combined evidence than jurors are? I see no reason to believe this. Most jurors don't know much science, neither do most judges. Almost, any judge will formally have been an attorney, except for the Supreme Court, where you don't have to have been. Most students in law school know very little science. Most of them were majors in history or politics or sociology or criminology or even philosophy or something. English literature, not the sciences. The number of students I see in law school classes with science degrees first is tiny. So judges don't know much science either. I don't think they're really any better qualified to make these judgments than juries are. Not that I think juries are very good at it, but I don't think judges are in principle better. I think the only possible answer to who's better is it depends on the judge and it depends on the jury.